speaking last, and perhaps I would be in a difficult situation to try and avoid whatever may have been properly canvassed here. But Mr. Chair, at the heart of this matter is a political process and political competition that, if you like, is as bruising as we have seen the conventional political contests. And history of football in this country can bear me witness on this. But allow me to narrow down on, now I had listed 9 points, but I will try and focus mainly on point number 6, number 7, 8, and 9. I will try my best, Mr. Chair. And a famous quote that I have invited this tribunal to look at, found in my submissions, is that Socrates, who is a great Greek philosopher, was once committed to prison for an offense that he felt, and his colleagues felt that it was unfair. Yet, even when Crito, who was his very close friend, and he felt that they would be admonished by the Athenians for not saving their friend, they plotted a way for him to escape from prison. But the great man that Socrates is, or was, said this, that there is in all things nothing found so worthy of respect as the authority of enacted law, which disposes well things both divine and human, and expels all iniquity. I am inviting this tribunal to be like Socrates, because here is FKF that is committed to the prison of the Sports Act and other applicable laws, and they're coming to you to play the role that Crito was trying to play to help Socrates escape from prison. This tribunal must not fall for that temptation. And I also want to say that, Mr. Chair, the petition as before this tribunal talks about or suggests that the registrar is using or applying directives that are mala fides, which means out of bad faith, unlawful, and unreasonable. I have referred to the case of Justice Odunga, in which the case of the Republic versus the CS Wario, and another, it is in my submissions, where the learned judge ruled, and I would read just a section of it, that the administrative bodies and tribunals or boards must act within their lawful authority, and an act, whether it be of a judicial, quasi-judicial, or administrative nature, as the case is with the directives of the registrar, is subject to the review of the courts on certain grounds. And the learned judge talked about, in undertaking these administrative decisions or functions, they must not act, or they must ensure that they act in good faith. No extraneous considerations influence their actions, and they do not mislead themselves in fact or in law. I submit before this tribunal that what the petitioners have done is merely make allegations against the person of the registrar, and have not demonstrated how those directives are a subject of this tribunal, and how they are mala fides, how they are unreasonable, and how they are unlawful, as the learned judge ruled. Having said that, Mr. Chair, I know the detail of all that is in my submissions. I want to go to my point number 3, whether Rule 20 of the Sports Registrar's Rules and Regulations means FKF and other national sports organizations can hold elections without the registrar's directives. I think I've expounded on my submissions, but I want to pick on one thing, that the registrar, in issuing a conditional certificate to FKF, did not cede her functions to register sports organizations as stipulated in Article 45 of the Act to FKF. And therefore, it is my submission that FKF needs to draw their membership in determining who their members are. The legal status of those applicants must fall and satisfy the requirements of the Act as provided for under the law and the regulations. And it is my submission that for them to merely suggest that they can pick clubs whose legal status has not passed the test of the law, as they themselves have committed to the Act, would amount to suggesting that the registrar's powers to maintain a register of sports organizations within the meaning of football was ceded to them. I think that would be a great travesty to the letter and the spirit of the Sports Act. I would also submit that having been issued with a conditional certificate on 24th of May 2018, they need to demonstrate before this tribunal that they indeed have made every effort to comply to conditions number 1, 2, 3, and 4 as outlined in their conditional certificate. At which point then the respondent should be put to her own defense as to why FKF continues to hold a conditional certificate. Otherwise, it would remain a blanket, hollow accusation against the registrar when they have failed to demonstrate how they have attempted to comply, leading to the letters that they have talked about. But whether the Electoral Board is unable to commence and proceed with its mandate, as was pointed out in the application, point number 1 and number 4 of the certificate of urgency suggested that before this matter is heard and determined, the Elections Board would be unable to commence and proceed with their mandate. But I want to draw the attention to the attention of this tribunal, and as the good president of FKF did already suggest, and Mr. Umwebu, that this same Electoral Board that the petitioners brought us here because it would not proceed with its work until this matter is heard and determined, has already received nominations and continued with the process, including issuing an elections calendar, which I think we have submitted in my early affidavit, and in the submissions I have pointed that out. I have alluded to an article that was published by the Daily Nation. I've given a link to that, where the Electoral Board chairperson was talking about how impressed they were with the number of, the amount of interest in this process. And they were calling for more before the end of that period. I believe that period is now over, and they are going on with the process. So I would want to challenge the petitioners to then either say that the Electoral Board that has issued the calendar and continued to process candidatures is strange to them, or is in defiance of the appointing authority, which brought us here, that until the matter is heard and determined, they should not proceed, or indeed confirm, at which point, if they confirm, I would invite this tribunal to invalidate those candidatures that may have been processed before this matter is heard and determined, because that is what the petitioner, who was the appointing authority, had indeed it is, and I'll get to where I'm talking about my submissions with respect to the prayers, but I want to submit that point number 1 and 4 in the certificate of urgency that came to this tribunal, it is suggested that the Electoral Board was unable to commence and proceed with the mandate until this matter is heard and determined. In fact, the words used in that as a matter of, let me just refer to that as a matter of, urgently as a matter of cause and necessity before the FKF Electoral Board proceeds to undertake its mandate. That is part 1. Part 4, again, I would read, allow me, that this matter is admitted to hearing and determined before, again, the FKF Electoral Board commences its mandate, so as to avoid unnecessary setbacks or unnecessary legal tussles between the parties. I would want to leave it at that in the interest of time, Mr. Chair, and move to my next point, which is on whether the petitioner's national official's term of office has expired and whether their continued stay in office to oversee the election is illegal. And on this one, Mr. Chair, there is something that I would want to allow me to, much obliged, and I will do that. The officials of the petitioner hold office for a term of 4 years. It is in their constitution, Mr. Chairman. And the term of the president and the National Executive Committee members is for 4 years. When does this mandate begin? Their Constitution of 2017, Article 37E, says it begins immediately at the end of the elective General Assembly of the FKF. The 2012 Constitution, if we would refer to it, and allow me this on the basis that, Mr. Chair, in the decision of 3rd of December 2019, this tribunal did rule that the enforceability of the 2017 Constitution is contested, and that was with regards to jurisdiction. And therefore, this tribunal drew its jurisdiction by invoking certain provisions, considering provisions of the 2012 Constitution. The same talked about those officials holding office for a term of 4 years. Second schedule of the Sports Act, Section C, talks about a period of between 2 and 4 years, and it is obvious that for FKF, as many other organizations, has gone for the maximum. Now, in the case of civil suit number 58 of 2004, which we have provided on our list of authorities, as regards to the term of office, it was very, very clear by Justice John Ohaga that this is stated in mandatory terms. If the term expires, one has to leave office. The court has not shown any saving article in the KFF Constitution or find any on its own. It continues and says the best thing they can do is to vacate office. Their term ended on 10th of February, and it is my submission that even clinging on to office in the pretext that they are holding elections was addressed by this ruling, where they said that the defendants, who are the officials there of KFF then, have no capacity as per the governing KFF Constitution to run its elections or do anything because their time in office has expired. And the learned judge said, there is no great fun or pride in having a constitution, whatever the body, that cannot be adhered to. I notice my time is up. Allow me to conclude that, therefore, this is a ruling by the High Court, and it is my submission that the solution we have at the end of this term is provided for under Article 55 of the Act that invites the Cabinet Secretary, and I've extensively quoted that. But allow me, Mr. Chair, I know there is a ruling in this tribunal that suggested that the provisions only apply with respect to the outcome of an inspection. But I wish to draw the attention of the tribunal to C of Article 55 that talks about where the sports organization concerned has been unable to conduct its affairs in a proper manner. This is with respect with the CS appointing a person or a committee to assume the management, control, and conduct of the affairs of a sports organization. And D, because, you know, proper manner is subjective, we can debate about it. What constitutes conduct in a proper manner? It goes on in D to say, remove any official of a sports organization who, in the opinion of the CS, has caused or contributed, and Mr. Chair, I want to emphasize, contributed to any contravention of any provisions of this Act, any regulations and directions made thereunder. And further down, it talks about bringing the sporting discipline into disrepute, and it is my submission that there is no greater offense. Nothing would be more grave to provisions of statute than expiry of term and or defiance of regulations as we have read. And finally, Mr. Chair, of course, again, that was canvassed in the ruling by Justice Mwera, which we have quoted in our submissions. Finally, I want to say that indeed what the petitioners are asking this tribunal to do is to give directives that are tantamount, that the long and short of it is for statute that establishes this tribunal, as it does establish the office of the registrar, to be broken. And this is why I'm saying that by them asking this tribunal to find the directives that are anchored on statutory provisions, on regulations that are given life from Article 73 of the Act, is tantamount to saying that this tribunal would also be standing on very, very dangerous grounds, because in my opinion, and it is my considered reading of the law, that this tribunal is a twin to the Sports Registrar. And therefore, if directives from the office of the registrar would be declared mala fides, unreasonable, unlawful, then this tribunal would be pointing a gun at itself with regards to directives that it has issued or will issue. Finally, Mr. Chair, in conclusion, allow me 1 minute. It does have jurisdictions and jurisdiction to review the decision, but such review must be restricted within the confines and provisions of law, whether statutory or constitutional or whatever statute or regulation that is applicable in the circumstances. And therefore, it is my view that yes, this is a tribunal that has my suggestion is that if indeed you find, and it is in my submissions, Mr. Chair, that the directives issued within the confines, strict confines of the law, are, as the petitioners have framed their prayers, that would be a very serious matter. in the face, not just as Nyakundi or any other person, but in the face of the law. And like I began by saying, there is no greater pride, or there is nothing so worthy of living than enacted law and showing respect to it. And Mr. Chair, I want to submit, I know you will have the chance to go through all the detail of my submissions, but it is my pleading before this tribunal that as a member, I'm not a member of the bar, I'm only a journalist whose interest, in conclusion, into this matter was drawn by a directive that there be a public notice in the newspaper. That is how I have ended up being an interested party and not a journalist. And I therefore submit that whatever we have been treated to hear that there was public participation, I have not seen, and my job description and designation bears me witness that there has not been any public notice to invite the public, as indeed we were invited as interested parties, vid that public notice that was advertised. And therefore, an email to your friends or people you know inviting them, or your members, does not amount to inviting the public to participate in an exercise. With those pleadings, I know I have overrun my time. Allow me to appreciate and say those are my submissions.